Welcome to UXL, where you can learn new skills anytime and anywhere. Visit uxl.com to explore our full course selection. This lesson is part of a larger course. Check the video description below for a link to the full course where you can enroll. If you enjoy our content, please like and subscribe. For your convenience, the course cover displayed on your screen provides the complete course title and lesson title. Let's proceed with the lesson. Lesson: Non-disclosure and non-compete clauses. Non-disclosure agreements and non-compete clauses have become integral components of employee onboarding and agreements, particularly in the context of California's unique legal landscape. These contractual provisions are designed to protect a company's proprietary information and competitive edge, but they must be carefully crafted to comply with state-specific regulations and to balance the interests of both employers and employees. NDAs, also known as confidentiality agreements, are legally binding contracts that prohibit employees from disclosing sensitive information that they acquire during their employment. This information can include trade secrets, proprietary business strategies, customer lists, and other confidential data. In California, the enforceability of NDAs is governed by the California Uniform Trade Secrets Act, which defines a trade secret as information that derives independent economic value from not being generally known and is subject to reasonable efforts to maintain its secrecy. The primary purpose of NDAs is to protect a company's intellectual property and maintain its competitive advantage. For instance, a tech company developing a new software application would require employees to sign an NDA to prevent the unauthorized dissemination of the application's code or design. Failure to enforce such agreements could result in significant financial losses and damage to the company's market position. According to a study by the Ponemon Institute, the average cost of a data breach in the United States was $8.64 million in 2020, underscoring the importance of robust confidentiality measures. However, NDAs must be drafted with precision to ensure they are enforceable. Overly broad or vague NDAs can be challenged in court and potentially rendered invalid. For example, an NDA that attempts to restrict an employee from discussing any aspect of their job without specifying what constitutes confidential information may be deemed unenforceable. Courts in California have consistently held that NDAs must be reasonable in scope and duration, and they must not infringe upon an employee's right to work in their chosen profession. In addition to NDAs, non-compete clauses are another common component of employment agreements. Non-compete clauses restrict employees from working for competitors or starting a competing business for a specified period after leaving their current employer. These clauses are intended to protect a company's investment in its employees and prevent the loss of valuable knowledge and skills to competitors. However, California has a strong public policy against non-compete clauses. Under California Business and Professions Code Section 16600, any contract that restrains an individual from engaging in a lawful profession, trade, or business of any kind is void, with limited exceptions. This statute reflects the state's commitment to employee mobility and free competition. In the landmark case of Edwards v. Arthur Anderson LLP, the California Supreme Court reaffirmed the state's prohibition on non-compete clauses, ruling that they are generally unenforceable unless they fall within a statutory exception. Despite this prohibition, employers in California may still include non-compete clauses in employment agreements, but they must be carefully tailored to fit within the statutory exceptions. One such exception is the sale of a business exception, which allows non-compete clauses in the context of the sale of a business or its goodwill. This exception is designed to protect the value of the business being sold and ensure that the buyer receives the full benefit of their purchase. Another exception is the protection of trade secrets exception, which permits limited restrictions on an employee's ability to work for a competitor if such restrictions are necessary to protect the employer's trade secrets. However, these restrictions must be narrowly tailored and reasonable in scope and duration. For example, an employer may be able to enforce a non-compete clause that prohibits a former employee from working for a direct competitor in the same geographic area for 1 year, provided that the restriction is necessary to protect specific trade secrets and does not unduly burden the employee's ability to find work. Employers must also consider the potential impact of non-compete clauses on employee morale and retention. Research has shown that overly restrictive non-compete clauses can lead to decreased job satisfaction and increased turnover. A study published in the Journal of Law and Economics found that employees subject to non-compete agreements were more likely to leave their current employer and seek employment in states with less restrictive non-compete laws. Therefore, employers should carefully weigh the benefits of non-compete clauses against the potential negative effects on employee morale and retention. In conclusion, NDAs and non-compete clauses are critical tools for protecting a company's proprietary information and competitive advantage. However, they must be carefully crafted to comply with California's unique legal landscape and to balance the interests of both employers and employees. NDAs should be specific and reasonable in scope and duration, while non-compete clauses should be tailored to fit within statutory exceptions and should not unduly burden an employee's right to work in their chosen profession. By understanding and navigating these legal requirements, employers can effectively protect their business interests while fostering a positive and productive work environment. This concludes the lesson. We trust you found this video informative and engaging. To enroll in the complete course, please use the link provided in the description below. At UXL, we are committed to your learning journey. Each course offers a certificate of completion, online support, and downloadable resource files to enhance your experience. If you found our content valuable, we invite you to like this video and subscribe to our channel. Thank you for joining us, and we look forward to supporting your continued pursuit of knowledge.